It's my pleasure to introduce to you my colleague in organizing this program, Raymond Koskie, sitting directly behind me, who is a senior partner at Koskie and Minsky. The research assistant for us is Harry Friedman, senior solicitor at the Ontario Labour Relations Board, and I'm Warren Winkler, and that's your cast of characters in terms of organizing this program. We'd ask that you refrain from any applause until afterwards. We have for you today what we believe to be a very good program. It's to be conducted by popular demand in seminar form, and we have two experienced labor lawyers in each seminar group. They are being assisted by a labor relations officer from the Labor Board, and those persons are under the strictest of instructions not to contradict anything that the lawyers have to say. So if they seem a little meek, you'll appreciate the reason for that. It's my pleasure to introduce for you now the Honorable Russell Ramsay, Minister of Labour for the Province of Ontario. Mr. Ramsay is a native of Sault Ste. Marie, Ontario, where he enjoyed a successful business career in the radio and television broadcasting industry. He has further distinguished himself by his devotion to public service in Northern Ontario, his almost limitless energy directed toward helping others has resulted in many honors being bestowed upon him, which include the Rotary Club Man of the Year Award and the B'nai B'rith Society Citizen of the Year Award. I trust that you will all agree with me that it is especially fitting that a man of these attributes is the Minister of Labour for our province. Mr. Minister.
Good morning, ladies and gentlemen. A little apprehensive about speaking to a group of any size these days because not too many weeks ago in Sault Ste. Marie I spoke at a father and son banquet, and after it was over, a little fellow about this high came up to me and said, "Mr. Ramsay," said, "you spoke too long." And I said, "Well, I had to speak a considerable length to make my point." He said, "Well," he said, "you spoke too loudly." And I said, "Well, I had to speak up because there wasn't a PA system in the room." And he said, "Well," he said, "you were lousy." So just as I was trying to think of an answer to that, his father came along and he said, "Russ," he said, "I hope young George isn't bothering you. He's at that crazy age where he repeats everything that he hears." I really am a little uneasy about talking to a group of distinguished barristers and solicitors such as yourself. I think I should be up on the other side and listening to and attending these seminars today, because one of the areas that I have felt very inadequate in as the Minister of Labour is in the field of labor law, and I say that sincerely. Perhaps I shouldn't admit it, but I have said on several occasions, not publicly, that I knew that my life was going to take this direction and that I was going to become a member of the legislature and a member of the cabinet, and particularly the Minister of Labour, I think I probably would have gone to law school before I did it. Before I get started, though, I have a letter here that I'd like to read to you that might be interested in. It's addressed to the tax collector, and it says, "Dear Sir, in reply to your request to send a check, I wish to inform you that the present condition of my bank account makes it almost impossible. My shattered financial condition is due to federal laws, provincial laws, city laws, corporation laws, mothers-in-laws, brothers-in-laws, sisters-in-laws, and outlaws. Through these laws, I'm compelled to pay a business tax, liquor tax, income tax, school tax, amusement tax, head tax, gas tax, light tax, sales tax, food tax, furniture tax, and excise tax. Even my brains are taxed. I'm required to get a business license, car license, hunting and fishing license, truck license, not to mention a marriage license, and a dog license. I'm also required to contribute to every society and organization which the genius of man is capable of bringing to life: women's relief, unemployment relief, and the gold diggers' relief. Also to every hospital and charitable institution in the city, including the Red Cross, the White Cross, the Purple Cross, and the Double Cross. For my own safety, I'm required to carry life insurance, property insurance, liability insurance, burglar insurance, accident insurance, business insurance, earthquake insurance, tornado insurance, unemployment insurance, old age, and fire insurance. My business is so governed that it's no easy matter for me to find out who owns it. I am inspected, suspected, disrespected, rejected, dejected, examined, re-examined, informed, required, summoned, fined, commanded, and compelled until I provide an inexhaustible supply of money for every known need of the human race. I can tell you honestly that except for the miracle that happened, I could not enclose this check. The wolf that comes to my door nowadays just had pups in my kitchen. I sold them, and here is the money. When I was invited to speak to you by the co-chairman of the Law Society's continuing education program on labor law, Warren Winkler and Ray Koskie, I was told that I could choose any topic I wanted. I know that Warren, for example, would probably be more interested if I decided to speak to you about the hunting and fishing near my home in Sault Ste. Marie. However, I doubt that such a discussion would have much relevance to a day devoted to examining the various procedural and practical issues concerning a union's organizing to obtain bargaining rights under the Labor Relations Act. It is the image of the labor relations process as one of confrontation and conflict which forms the major theme of my talk today. You should be aware that it is my aim and the aim of the Ministry of Labor and the Labor Relations Board to reduce, as much as possible, disputes which arise in the labor relations arena, particularly in the circumstances that you'll be examining today, the organizing of a non-union company. As George Adams has noted, and I quote, "The arrival of a trade union is no neutral event to any employer. To an owner manager with a relatively small workforce and competing mainly against other unorganized employers, the arrival of a trade union can be perceived as disastrous. The perception of a branch plant operated by an unorganized multinational may, however, be no different." That observation, I think, accurately portrays the emotions and attitudes of more than a few employers who, for the first time, face a union's organizing and certification drive among their employees. However, it is to the credit of the labor bar and other labor relations professionals that this attitude is moderated and restrained. As you know, or will, it is to be hoped, gather by the end of the day, the Labor Relations Act confers upon employees and their trade unions the right to engage in collective bargaining, notwithstanding the wishes of their employer. In recognition of this right, the Labor Relations Act prohibits conduct which interferes with the exercise of this right. In the last fiscal year, 1,101 applications for certification were disposed of by the Ontario Labor Relations Board, and only 158 of those certification proceedings, or approximately 14%, had unfair labor practice complaints associated with them, while the board dealt with a total of 622 unfair labor practice complaints during the same year. It was required in only 15% of those cases to hold a hearing and direct that particular remedial action such as reinstatement, compensation, or posting be taken. The balance of the complaints were either dismissed, withdrawn, or settled. It would therefore appear that unfair labor practice complaints are associated with only a small number of actual certification applications, and the vast majority of complaints are, in any event, settled by the parties, usually with the assistance of a labor relations officer. However, I don't wish to give the impression that a simple code of prohibited conduct would be enough. Administrative, remedial, and preventative initiatives by both the Labor Board and the Ministry have all contributed to the reduction in conflict and fostering a healthy collective bargaining climate. I'm sure we all agree with the then Chief Justice Esty, who, when commenting upon a Labor Relations Board proceeding which had come before the Ontario Court of Appeal, observed that labor relations delayed is labor relations defeated and denied. That observation by the learned justice was not a revelation for labor relations practitioners. Delay is harmful to good labor relations. Delay, particularly at a critical stage in the relationship, that is, during an organizing and certification drive, can have a devastating impact upon the exercise by employees of rights under the Act. In recognition of this, the Act was amended in 1975 to permit interim certification by the board where there is a dispute over the composition of the bargaining unit, the outcome of which could not affect the trade union's right to certification. Prior to that amendment, the board appointed labor relations officers to investigate virtually all bargaining unit disputes before it made its determination. These investigations often took considerable time to complete, adding an average of 60 days to the time taken to dispose of the case. Since 1975, cases in which the board issued an interim certificate have taken an average of 21 days to dispose of, a substantial reduction in the total elapsed time. In recent years, the board has also developed several key administrative programs which have both reduced the time taken to dispose of certification proceedings and promoted an attitude of settlement rather than of litigation of the issues in the certification process. The board's waiver of hearing program, in which an officer contacts the parties prior to the hearing, has been quite successful. Through that program, many routine certification applications can be resolved without a hearing on the agreement of the parties. This has been particularly useful to Northern Ontario parties who are now able to conduct routine matters over the telephone. During the first year of the program's operation, 76% of the cases in which the board officer contacted the parties prior to the hearing were disposed of without a hearing. And I understand that more and more practitioners are willing to participate in the program with the consequent saving of time and expense for their clients. The emphasis by the board on settlement rather than litigation at certification proceedings continues throughout the process. The board hears all certification applications on the same day of the week, which is Friday, in order to facilitate its settlement efforts. A team of officers under the direction of a senior labor relations officer is assigned to certifications each week. The officers are completely briefed on the contentious issues which the applications appear to raise. When the parties arrive, the officers attempt to help them resolve those disputes before the actual hearing before the board. The officers will meet with the parties in almost every case to explore common ground and to provide an opportunity for settlement. If no settlement is reached, the parties proceed with the hearing that same day. Even where a settlement is not forthcoming, the issues are usually reduced and simplified, thereby shortening the time taken in the hearing itself. These settlement efforts also continue if a labor relations officer is appointed to conduct an examination into a dispute over a bargaining unit description. Often, lengthy examinations of employees' duties and responsibilities are dispensed with through the settlement efforts of the officers. Such settlements can achieve a satisfactory labor relations result and the saving of both time and resources. In the last fiscal year, approximately 70% of the cases in which an employee's status was an issue were settled by the parties, thus eliminating both the need for a hearing before the board and, in many cases, the preparation and distribution of lengthy reports. As a result of these settlement programs, the time taken by the board to dispose of certification proceedings has been significantly improved. In the last fiscal year, approximately 65% of all certificates issued by the board were granted within 28 days of the filing of the application, while approximately 86% of all certificates were granted within 8 weeks of the date of the filing of the application. Where settlement efforts break down, however, the board is required to make determinations in unfair labor practice proceedings as well as certification. This, of course, raises the issue of the board's application of reverse onus. Those who object to the reverse onus in unfair labor practice cases should be aware that the trade union success rate in such matters has not significantly altered over the years, and that upwards of 60% of these matters are dismissed. For those of you who question the board's commitment to the statute's objectives, I merely advise you to study the array of remedies devised by the board over the last few years. I would also point out that the board has been just as expeditious and novel in dealing with unlawful strikes and picketing as recent cases and procedures will attest. Once a certificate is granted, the process of collective bargaining begins. And while the board's role is no longer as direct or active at this stage, programs within the ministry are in place to assist the parties during their first contract bargaining. The Conciliation and Mediation Branch, through its Preventative Mediation Program and Conciliation Program, will monitor bargaining. From the time of certification, the progress of first agreement negotiations is followed so that assistance can be offered where it appears that a fledgling relationship is encountering difficulty. Negotiations following a no-board report are also closely monitored so that the parties are aware of the mediation services available to them and can have access to a mediator without delay at this critical period. The vast majority of certificates issued by the board have resulted in first collective agreements. On average, in the 2 fiscal years ending March 79 and March 80, 86% of all first agreement negotiations ended in a collective agreement. Not only is it gratifying that our programs permit these high numbers of settlements, it is important, I think, to note that a majority of those settlements are reached through direct bargaining by the parties themselves. Our conciliation officers and mediators have participated in the negotiation of approximately 43% of those first contracts, with less than 7% of those first contract disputes being settled after a strike. While the 1975 legislative initiative had an impact on reducing the time required for certification before the board, the 1980 amendments have, I believe, further assisted employers and trade unions in establishing and maintaining a collective bargaining relationship. The amendment requiring a compulsory dues checkoff provision in a collective agreement upon the request of the union resulted from several lengthy, bitter, and highly publicized strikes where this union security demand was the major issue in bargaining for a first agreement. During the year prior to the enactment of the amendment, there were 46 work stoppages associated with first agreement negotiations. Those disputes involved 3,370 workers and resulted in 124,720 man-days of lost production. In the year after the enactment of that legislation, that is from June 1980 to May 1981, there were work stoppages involving 2,248 workers and 53,140 man-days lost. While the number of first agreement work stoppages were relatively equal between years, that is 46 in the year ending May 80 and 44 in the year ending May 81, the number of workers involved, and particularly the man-days lost, have been considerably reduced. Even more significant is the dramatic reduction in the average length of the dispute from 51 days in the former period compared to 32 days in the latter. Although it is not possible to attribute the reduction in the severity of first agreement disputes as measured by man-days lost entirely to the amendment, I believe it has been a significant factor. There were less than half as many man-days lost in the 12-month period immediately following the amendment as in the 12-month period immediately prior to it. The other amendment in 1980, requiring a final offer vote at the request of an employer, was not thought of as primarily affecting first agreement disputes. Of the 52 requests for a final offer vote, as of this past Friday, 15, or approximately 29%, related to first agreement disputes. In those 15, the employees in 7 cases rejected their employer's final offer, while settlements were reached in the other 8 cases before the vote was held. In addition to the programs intended to promote industrial harmony and reduce conflict in first contract bargaining, my ministry, through the Office of Arbitration, participates in the resolution of grievances which arise under a collective agreement. Grievance settlement officers are appointed not only to assist the parties which resort to expedited arbitrations under Section 48 of the Act, but also those which are proceeding to arbitration under their collective agreement. Of the 1,463 grievance proceedings in which grievance settlement officers were appointed, 999, or approximately 68%, were settled by the officers. The grievance settlement program, as well as the preventative mediation program, are available to help the parties through difficulties in their collective bargaining relationship. Furthermore, the backdrop of the Labor Relations Board's remedial authority, particularly in certification proceedings and in first agreement negotiations, tends to encourage the parties to settle their disputes rather than litigating them before the board. The success of a collective bargaining relationship is, in my view, primarily a function of the attitudes and practices of the participants. The system will work if the actors in it want it to work. The Labor Relations Act, the board's procedures, its remedial authority, and my ministry's initiatives and programs are all designed to foster an environment conducive to healthy collective bargaining. The ultimate responsibility for the well-being of collective bargaining, however, rests with you and your clients. I don't wish to be accused, especially at a distinguished gathering such as this, of special pleading on behalf of my ministry or one of the tribunals for which it is responsible. However, as a new minister, I have been impressed with the quality of the public servants engaged in industrial relations here in Ontario, and I mean this sincerely. I think it's generally accepted that we have one of the most able and professional cadres of conciliators and mediators in any comparable jurisdiction. Moreover, I think the quality and wisdom of its jurisprudence attest to the caliber of the Ontario Labor Relations Board, so ably led by George Adam and his First Lieutenant Kevin Burkett. I believe they are setting the pace of the body of labor relations jurisprudence that will serve as a model for administrative tribunals across the country. It would be easy for me to conclude now and avoid the contentious aspects of Bill 179, the government's inflation restraint program. There is no doubt that our legislation, like that of the federal government and similar legislative initiatives in other Canadian jurisdictions, curtails some collective bargaining rights for a period of time. Speaking personally, I regret the necessity for such curtailment. It will not surprise you to know that my political philosophy involves enthusiastic endorsement of the free enterprise system. Collective bargaining is one of the key elements in the free market system, permitting, as it does, individuals to band together and bargain in the marketplace for appropriate recognition of their contribution to the enterprise of which they are a part. In recent years, and particularly in recent months, there has been increasing strains on this system. The challenge we now face is whether this bargaining structure which we have created can survive and flourish in an increasingly turbulent economic environment. There are those like Bob White of the UAW who argue with considerable conviction that the system can and will survive, and that unions and management are significantly pragmatic and inventive to adapt to what in some cases amounts to crisis situations. The proponents of public sector wage controls, on the other hand, argue that the same forces of discipline do not operate where competitive pressures and the profit considerations of the bottom line are not present. Thus, despite the apparent inequity, it is the government's view that it has an obligation to mandate restraint in those areas, and at the same time to encourage the private sector to follow suit on a voluntary basis. I believe that in the long run, this approach, whatever the short-term pain, will benefit Ontario workers. The hard facts are, as Sylvia Ostry pointed out just the other day, that Canada has lost its competitive edge. Mrs. Ostry has, in fact, pointed out that Canada's productivity performance has been the worst in the Western world. No one likes to hear the words retrenchment and consolidation. They smack too much of defeatism. Nonetheless, I believe that we must face reality and make the sacrifices necessary to participate in the economic recovery which does lie ahead. No one argues that wage restraint will provide an instant solution. Realistically, our recovery is tied to recovery in the United States and Western Europe. However, unless we are well positioned to engage in that recovery, unless, in short, we get our unit labor costs and productivity performance in line with our major competitors, we will not even be in the race. I know I have strayed from the rather technical subject of collective bargaining and dispute resolution, but I did want to share these observations with you. They are relevant because, in my view, unless we are prepared to make hard choices now, There is a real question as to whether collective bargaining, as we have known it for the last 40 years, will survive as the way in which income is allocated in our free and open system. I appreciate the opportunity to be here today, and I trust that your deliberations throughout the day will not only be informative, but productive. Thank you very much.
Thank you very much, Mr. Minister. I was interested in your comments with respect to the government's proposed restraint bill 179. It sort of reminded me of the fact that Mr. Ramsay is known among government circles as being one of the most approachable of the cabinet ministers. There's only one catch, that you have to be up at 6:30 in the morning to meet with him if you want to meet with him. And that seems to me to be an indication, speaking of restraint, as to what the minister's priorities will be this year. I suspect that we can look to a somewhat extended working day, commencing work as he does at 6:30 in the morning. Be that as it may, I'm sure that will be received with as much enthusiasm as the government's Bill 179 has been received. In any event, Russ, I want to thank you again for coming here. We certainly enjoyed your comments, and we'll look forward to the progress of Bill 179 as well. And speaking of restraint, as most of you probably know, this program was originally scheduled several months ago as part of a two-day program. And I suppose because of the economy, among other reasons, the turnout wasn't as enthusiastic as it is today, and so we had to cancel it. We're certainly much more pleased with the turnout we are getting today. To remind you of the particular concept of our program is probably the only one which the Law Society puts on, which is open not only to lawyers but also to non-lawyers. This is an experiment which we tried several years ago and has worked to date, and therefore we will be continuing it. One slight change this year is that, as you note, the entire program, except for the minister's address, is devoted to seminars, and as Warren indicated to you earlier, it seems that most people appreciate the knowledge they obtain from the seminars as opposed to having panel discussions. But the one change we have made this year is that the groups are divided. We have attempted to divide the groups in accordance with the relative interests of those who have registered. And so, for example, there will be one group which will be a union group consisting of lawyers and non-lawyers involved in the construction and non-construction industry. And there are separate groups, for example, industrial, and that will be open to lawyers and non-lawyers as well. Now, these group postings are located outside of this classroom as well as outside the classroom on the third floor. And we have attempted to divide you in accordance with the interests you indicated when you completed the application form. However, no one is being held to those particular groups, and if for any reason we haven't put you in the group you would prefer, you are certainly free to select one of your own choice. I want to remind you that all of the seminar rooms are located up the escalator just outside of this particular classroom, and coffee will be served this morning as well as this afternoon. Of course, lunch is available too downstairs. So with that in mind, I think that we can now adjourn this morning and proceed to the seminars. Thank you very much.